Mason Hayes & Curran has been involved in a large number of nursing home transactions over the last number of years. The market's been extremely buoyant, and we've acted for a lot of international and domestic acquirers of different nursing homes and groups of nursing homes. And we've seen since sort of the pandemic started two different situations, I suppose, where in the first 5 or 6 months, the transactions did stop completely. And then they resumed in earnest sort of last September. So I think what we're seeing in terms of there being huge numbers of deals is issues recurring on those deals, which we wanted to talk to you a little bit about in this vlog. So first of all, we're seeing issues with contracts for care and the compliance of those with certain CCPC guidance. We're seeing on transactions the advent of W&I insurance, that's warranty and indemnity insurance. And we're also seeing impending requirements in terms of the state of the premises and HICWA requirements around that. So we're going to talk to you about those topics today. So first of all, I'll hand over to Emer Lyons, who's going to speak to you about contracts for care.
Thank you, Robert. Yes, you're correct. We are seeing some compliance issues arise in our due diligence exercises over and over again. And one of those relates to the CCPC guidelines in relation to contracts of care, which were introduced back in 2019 and which were recently refreshed in June of this year. We're often asked to review template contracts of care. It might be by an operator who just wants to streamline their business, or it might be by a seller who's trying to get its business ready for sale, and oftentimes it's by purchasers who are carrying out pre-acquisition diligence. But more often than not, we are seeing the same issues come up in these contracts of care, and where they are not compliant with either consumer law, the guidelines, or there's data protection issues. So I suppose what's important to remember here is that these contracts of care should be drafted in very plain, intelligible language and should be very easily understood by both residents and their families. Contracts which contain legal jargon or which contain unclear or ambiguous terms will be deemed to be may be deemed to be unenforceable. And we also see other types of clauses in these contracts which we would have concerns about. For example, there could be unilateral termination clauses or unreasonable notice periods. There might be clauses which seek to limit or exclude the liability of the nursing home where residents' possessions are damaged or lost, or penalty clauses which include, for example, interests on accrued fees. It's also important to remember when looking at contracts for care that often these contracts have guarantor provisions. And it's really, you need to remember that the guarantors also need to understand what their obligations are under these contracts and when those obligations might be triggered. So I suppose what the CCP's refresher in June of this year serves to do is to remind everybody that they need to look at these guidelines and that they are something that is coming up in due diligence exercises. They may influence the suite of warranties or possibly indemnities that a buyer might look for, and they are also being raised by HICWA when they're doing the reviews.
Thank you very much, Emer. And I think that's contracts for care point. It's one of the things that equally we would see as a really relevant issue in transactions, but equally clients, repeat clients of ours would be coming to us with questions about those types of issues. And there are others that Emer will speak about in a minute. One issue that's very much to do with transactions that we wanted to talk to you about as well is warranty and indemnity insurance. Now, warranty and indemnity insurance is something that it's a product that's put in place on some transactions where a company or business is being bought. And it's a very useful tool to kind of to close the gap between a buyer and a seller on a given set of warranties and limitations and things like that. It's a product that's used increasingly in the market generally on deals, but we've certainly seen it more on nursing home transactions recently than would have been the case previously. What you'd expect to see if there's an auction scenario, so if you're selling, for example, a group of nursing homes and there are various bidders who are interested, which in the current market, that tends to be the case when any comes up for sale. But what you would expect to do if you have that kind of competitive tension is to introduce warranty and indemnity insurance into the package. And on that basis, sellers can really get away from the transaction with very limited personal exposure at all to take forward. So it's a hugely useful tool from that point of view. And of course, it can be used even on less competitive situations where there's a bilateral deal between a buyer and a seller for a single nursing home. So, you know, and how it works is that, you know, the buyer can have a direct recourse against the insurer if it's a buyer policy, and could have a much higher limitation or much higher period of time that they can recover under the insurance than might be the case if you had a deal just between a buyer and a seller. So it's an increasingly useful product and increasingly used, and we're certainly seeing it in the nursing home sector on the deals we advise on. I'm going to hand back to Emer then, who's going to talk a little bit about some HICWA regulations that are coming fast down the tracks.
Yeah, another compliance point that we often see raised on transactions is relates to the 2013 and the 2016 regulations, which were introduced under the Health Act 2007, and which placed obligations on nursing home providers to improve their premises in advance of a specific deadline, which is the 1st of January 2022. There's been a lot of talk about these regulations, and I think they have been focused on a lot by providers, and also they've been looked at by their technical advisors. However, what's important to remember here now is that after the 1st of January 2022, if you're not compliant, for example, if you don't have the requisite floor areas, if there's too many residents per bedroom, if you don't have suitable bathroom facilities in close proximity to the bedrooms, or you don't have sufficient dining facilities in the nursing home, these are issues that will most likely be raised by HICWA when they're carrying out their inspections, and which might influence your renewal of your registration, or it might result in conditions being imposed on your registration. There's also other penalties such as fines and terms of imprisonment that need to be considered, and it's definitely an area that is focused on by buyers when they're purchasing a nursing home and carrying out their due diligence, like I said, particularly on the technical side. So if there are non-compliance issues, you can probably expect it to be raised, and it will most likely influence the suite of warranties and indemnities again that a buyer might look for, and possibly even affect a purchase price. So these are, I suppose, in addition to the contracts for care, it's a non-compliance issue if you don't if you don't comply with the obligations, and this is the same thing again, however, and is getting a lot of traction from the likes of HICWA also.
Thanks very much, Emer. So I think in conclusion, what we've looked at there is kind of two different types of issue from a transactional point of view. One is very much a due diligence issue. So these are issues to look out for whether you're on the sell side or the buy side on a nursing home transaction. Things like, you know, these HICWA regulations, contracts for care, they're coming up repeatedly. So I think being aware of these sort of potential problems in advance and trying to overcome them or be aware of them is very useful. I think equally, when you're preparing for a transaction, it's very useful to understand the transaction structure and what's likely to be required, or what's, you know, for example, understanding if you aren't generally involved with transactions and you're selling a nursing home business, for example, what warranty and indemnity insurance is and how it can help you in terms of the deal. I think that those sorts of questions are very useful to work through with your advisors in advance. So that in conclusion, I think it's worth doing that exercise, and there's certainly plenty to think about in a very, very buoyant market. Thank you.